Hi guys, Florida Real Estate Sales Associate course, Chapter 2, Real Estate License Law and qualifications for licensure. The Real Estate License Law was officially designated Chapter 475 of the Florida Statutes in 1941. Qualifications. Applicants for a Florida real estate license are not required to be a resident in the state of Florida or to be a citizen of the United States. An applicant who is a non-resident or licensees who become non-residents within 60 days must file an irrevocable consent to service form with the department. Applications must have attained the age of majority, which in Florida is 18 or older, and have a high school education or equivalent. Courses may be completed by classroom instruction or distance learning. When completed by classroom attendance is mandatory. Absence in excess of 8 classroom hours will disqualify a student from taking the final examination. When completed by distance learning, students must affirm they have completed the required number of study annals. A timed final examination must be completed to receive credit for the course. Students that pass the course final examination will receive a certificate of satisfactory completion, which qualifies an applicant to apply for the state examination. The certificate must be presented to the department as proof of successful completion of the pre-license course. The certificate may be mailed to the department with the application to take the state exam, or may be presented to the testing service at the examination site. Both application and end of course certificate of completion are good for 2 years from their date of issue. Members of the Florida Bar are exempt from taking the 63-hour pre-license course for sales associate. A copy of the membership card in the Florida Bar must accompany the application to take the state examination. Change of perspective. There we go. Application to take the state examination requires submission of a completed real estate application package and a required fee that includes the fee for the initial license, along with electronic fingerprints taken and submitted by the state-approved vendor. Applicants must disclose any criminal convictions other than minor traffic infractions. Applicants must read questions 1 carefully and disclose all convictions. Failure to answer correctly may result in disciplinary action, including denial or revocation. Completed forms and a check made payable to the Division of Real Estate are mailed to the division. The department has 30 days to review an application. If the application is found to be incomplete or contain an error, it will be returned to the applicant. Once a complete application has been received by the DBPR, the applicant must appear for the state examination within 2 years. Failure to appear within 2 years would require the applicant to file a new application. If an application to take a state exam is denied by the Florida Real Estate Commission, the applicant must be notified in writing and allowed 21 days to file for a formal hearing before an administrative law judge in accordance with Chapter 120, the Florida Administrative Procedures Act. Sales associates may be licensed under a broker or owner-employer, such as a developer. Brokers are registered and licensed. Owners and employers are registered with the DBPR but are not licensed. A real estate sales associate that is paid on a commission or transactional basis must have an employer and must be paid only by his or her employer for real estate services. Post-license education. All sales associates, including attorneys with sales associates license, whether actively or inactively licensed, must complete a 45-hour post-licensing course prior to the expiration date of their initial license period. Individuals with a 4-year degree in real estate are exempt from post-licensing requirements. Failure to complete this required course prior to the expiration of the initial license will cause the license to become void, and the licensee will be out of business. Any licensee who has received a 4-year degree in real estate from accredited college or university is exempt from taking the sales associate 45-hour post-license course. Florida licensed attorneys are exempt from the sales associate pre-license course but are not exempt from the 45-hour post-license course. Continuing education. Following the initial license period, all sales associate, with the exception of actively licensed Florida attorneys who are in good standing with the Florida Bar, whether active or inactive, must complete 14 hours of commission-approved continuing education prior to license renewal during every 2-year license period. The continuing education requirement can be accomplished by attending classroom instruction or by successful completion of a commission-approved distance learning course. If taken by distance learning, a written examination consisting of 30 questions must be included and passed to get credit for the course. An applicant for a broker's license may choose to continue employment in a sales associate's capacity with a current employer subsequent to passing the state examination. If so, the applicant will be registered as a broker associate after passing the examination. Should a broker associate become inactive, he or she will be issued an inactive broker's license. Continuing education. Following the initial license period, all brokers, with the exception of actively licensed Florida attorneys who are in good standing with a Florida bar, whether active or inactive, must complete 14 hours of commission-approved continuing education prior to license renewal during every 2-year license period. The continuing education requirement can be accomplished by attending classroom instruction or by successful completion of a commission-approved distance learning course. If taken by distance learning, a written examination consisting of 30 questions must be included and passed to get credit for the course. Mutual recognition. Florida does not have reciprocity with any other state with regard to real estate licensing. Reciprocity would allow for licensees of one state to practice in another state. However, the state of Florida has entered into contractual agreements with a limited number of states recognizing the similarity in the content of their mutual education and experience requirements for real estate licensing. It's called mutual recognition. A non-resident of Florida that has been actively licensed in another state for 2 years or more who wishes to become licensed in Florida and resides in a state with whom Florida has entered into a mutual recognition agreement may apply and take a 40-question law examination. Non-resident licensees, whether from a mutual recognition state or otherwise, must take all post-license and continuing education courses required of Florida licensees. Residency in Florida can be claimed by anyone that has resided in the state for 4 months or more during the previous year or has done so for at least 4 months during the preceding 12-month period. Statutory services. Florida 475.01. Florida statute. I don't know what I just said. Florida statute 475.01 specifies the following as services of real estate requiring those that perform such services to possess a current and valid active Florida real estate license. Exchanging, leasing, listing, property management. Memory device, a bar sale. The most common services of real estate are appraising, buying, auctioning, renting, selling, advertising, leasing, exchanging. A bar sale. Exemptions. Florida 475.01. I'm not sure what I keep on saying. Florida statute. I think I said Florida statute. Florida statute 475.011 identifies those persons or entities that are exempt under law. An exemption allows certain unlicensed persons or entities to perform services in the state of Florida for compensation that might otherwise require a real estate license. Exemptions include the following. Attorneys in facts are persons granted authority under a power of attorney to act for others in some capacity, such as signing documents. Court appointees are persons approved by a court of law to perform services of real estate. They may do so for a fee or salary, but not a commission. Certified public accountants, attorneys at law, salaried employees for government agencies, railroads, rural electric cooperatives, and public utilities. Salaried employees of an owner or registered broker for an owner of apartment community who works in an on-site rental office at the apartment community in a leasing capacity. Individuals, partners in a partnership, corporation salaried employees, persons dealing strictly in personal property transactions, cemetery lot salespersons, renting of a mobile home or recreational lot, salaried managers of condominium or cooperative apartment complexes, only if they're arranging rentals for no greater than 1 year. Radio, television, cable enterprise employees, full-time graduate students, owner of one or more timeshare periods, timeshare exchange companies, registered, licensed, and certified appraisers, any person or other entity that rents or advertises for rent, transient occupancy of public lodging establishments such as hotels, motels, and rooming houses. Dealers registered under the Securities and Exchange Act of 1934. Those are all exempt. The Florida real estate license law requires a sales associate or broker associate to be employed as an agent of either a broker or an owner-employer before performing real estate services for compensation. A real estate sales associate or broker associate may not be directly employed or compensated by a member of the public. A broker associate is qualified to receive a broker's license but chooses instead to be employed under the direction, control, and management of an actively licensed broker or owner-employer. In this capacity, the broker associate acts as a sales associate, not as a broker. Employment by a broker. When employed by and licensed under a broker, a sales associate or broker associate acts as the broker's agent in performing services of real estate. A sales associate or broker associate cannot receive compensation for performing real estate services from anyone other than his or her employing broker. A sales associate or broker associate can only work for one broker at a time. An owner-employer is an individual or entity that is in the business of buying, owning, and or developing real estate. The owner-employer is registered with the department but receives no real estate license. And that's the end of chapter 2.